Arbitration when you're sued for debt. Brought to you by Kenneth Chabert at yourlegalagot.com. Your advantage if you're being sued by debt collectors. Some contracts require the parties to give up their normal legal rights to a judge, jury, and legal process and accept arbitration. It's pretty much always the richer party that pushes for arbitration or requires it in form contracts, which in the law are called contracts of adhesion. Ever wonder why? I didn't think so. It's too obvious to have to wonder about, isn't it? Arbitration is a method whereby the parties supposedly choose an impartial third party and some simplified rules and find a way quickly to judgment, which is supposedly fair and sounds good, and it spares all that mess and fuss of real judicial process. The way the big corporations have managed to push this one over on us and get it done is one of the great scams of our time, in my opinion. Arbitration is almost always done through some large arbitration agency like AAA, American Arbitrators Association, or something like that, which is supposedly perfectly impartial, and it has the rules to prove it. It's just that the arbitration agencies know that no consumer was ever responsible for causing an issue to be referred to arbitration. The rules are simplified to expedite discovery and decision. Guess whose advantage that almost always turns out to be? Arbitration means no jury trial. It means that the case will almost always be decided by some jaded bureaucrat who's heard everything you have to say, and at the end of the day depends upon the debt collectors and banks for return business and his livelihood. If that doesn't sound like it's going to be fair to you, then you'll understand why lawyers representing debtors have opposed arbitration clauses so vigorously. The lack of public records and severely reduced rights of appeal add to my skepticism. So you may wish to avoid any kind of credit card that includes the arbitration provision in its contract in the future. All by itself, that's a good enough reason to get another kind of card, in my opinion. To be fair, my opposition to arbitration is largely for the same reason its proponents want it. It greases the path towards a swift and decisive decision regarding a dispute. Of course, considering that the FTC found that one debt collector collected 80% of its money from people who never owed the money, a justice-minded person might question the value of speeding up the process, or the need to do it. I believe that a person willing to fight a debt collector has a very good chance of winning, even representing himself in court. This chance goes down in arbitration for various reasons. But I did win one once, and never even had a clue why, so I know it can happen. For now, however, if you hope to avoid arbitration, you must check and double-check the provisions that the bank or debt collectors are asserting give it the right to arbitration. Some courts have ruled that the debt collectors cannot assert the right to arbitration that was created by a contract between the original creditor and the consumer. That makes sense when you consider that the unsophisticated consumer would surely not have contemplated violations of the Fair Debt Collection Practices Act by another company when signing the contract with the bank. The law also requires that the provision providing for arbitration be conspicuous, so that it is usually in bold, large print. If that is missing, you may be able to challenge the debt collector's use of arbitration. If you're going to go through arbitration, you should know a few things. First, there will be rules controlling the process, and you need to know them right off the bat. Getting those rules and reading them carefully at the beginning is more important in arbitration than lawsuits, because the time provided for arbitration is normally so much shorter. Likewise, understanding the purpose and effects of the debt game played by the debt collectors is also extremely important. You will have little time to flounder around not knowing what you're up to. If you're going to defend yourself in an arbitration proceeding, which I, of course, suggest, you must act quickly. You must learn both your rights and the rules as soon as possible. You won't have much time to learn them during the process. On the other hand, because the rules are somewhat relaxed, they're often going to be slightly more understandable. And all of your substantive rights, that is, the laws controlling what, if anything, you owe, will remain the same. Even if it isn't my favorite forum, it is possible to win an arbitration, and standing up for yourself always makes it more likely you'll be able to settle the case if you choose to try that. You may not consider this video or anything I say in this or any video as legal advice. I can't give you legal advice, but as a former lawyer, I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegup.com. Get my litigation manual and forms, and defend yourself from the debt collectors.